Hi guys, just wanted to make a quick video because I got an email from the courts in San Diego regarding the Padron versus Watchtower case. So this just came out today. You can see up here, filed November 9th, 2017, which is today. As you guys are aware, the Watchtower was fined $4,000 per day in order to produce documents that they've been keeping regarding child abuse cases. But the Watchtower have been defiant in providing these documents. So, of course, the Watchtower did not want to pay $4,000 a day fine. So what they did was they appealed the court's decision. And so here is a response from the appellate court regarding the Watchtower's appeal regarding having to pay this fine. So it says, appeal from an order of the Superior Court of San Diego County, Richard E.L. Strauss, judge, affirmed. And then it lists the other lawyers, including the Zalkin law firm, who is the lawyer for Padron. It continues to say here, this case presents the issue whether a superior court can impose a hefty daily monetary sanction on a party who steadfastly refuses to comply with a discovery order. Here, the court ordered Watchtower Bible and Tract Society of New York, Inc. to produce documents responsive to a specific request for production. Per the court's order, the documents would be redacted to protect certain third parties' privacy interests and produced subject to a strict confidentiality and non-disclosure order negotiated by Watchtower. In addition, the court ordered Watchtower to look for documents and files it represented on multiple occasions to be in its possession, custody, and/or control. Watchtower informed the court that it would not comply with the order. As such, plaintiff Osvaldo Padron brought a motion for monetary sanctions against Watchtower for its discovery abuses. The court awarded sanctions in the amount of $4,000 per day for non-compliance with the order, and Watchtower appeals that order. So this is a very lengthy document. I believe there's 39 pages. So I will have the link in the description. But if we just skip here to page 17, I'll just read something that I found to be interesting. So here on page 17, after entertaining oral argument, the Superior Court granted Padron's motion for monetary sanctions. The court explained, in this case, there is clear failure to comply with a discovery order on the part of Watchtower. First, Watchtower failed to properly comply with the court's March 13th, 2015 order and produced documents with excessive redactions. After the court adopted the discovery referee's recommendation as an order, Watchtower has unequivocally stated it will not comply. By the time of the hearing of the motion for sanctions, it will have been over a year since the initial order and almost 3 months since the recommendation was adopted. In the period since the recommendation was adopted, Watchtower has shown no effort or willingness to comply with the discovery order. Based upon the history in this case and Watchtower's statements at the April 8, 2016 hearing, the court finds that Watchtower's failure to comply is willful. Watchtower argues that its failure is not willful because it has no control over exJW documents. However, Watchtower clearly has control over the documents it has already produced and could revise the redactions with regard to those documents. This is obviously and clearly within the scope of Watchtower's powers, which it chooses not to exercise. Continuing to repeat its prior unsuccessful arguments in opposition to the discovery order further illustrates Watchtower's obstinacy in compliance. Further, based upon the ambiguous statements made by Watchtower's counsel, there is no reasonable dispute that Watchtower is simply refusing even to attempt to comply with the court's order. Wow, Watchtower. Now the world can see how dirty you are when you're in the courts. And to think I was so proud to tell everyone of all the victories we've had over the years in the high courts and Supreme Courts for their First Amendment rights. But now we see, how dirty they can be when dealing with Satan's world. But I wanted to read the conclusion of the appellate court's findings regarding the Watchtower. I think it's on page, let's see. Okay, so here's a summary on page 38. It says, in summary, we agree with the Superior Court. So remember, this is the appellate court's report. So we agree with the Superior Court that third-party privacy rights are adequately protected by the procedures in place, and Watchtower has not shown us otherwise. Also, we are not persuaded by Watchtower's argument that the production of the redacted documents under the confidentiality and non-disclosure order would violate its and its members' First Amendment rights. The record supports the Superior Court's finding that the production of the responses, to the March 14, 1997 letter does not infringe upon Watchtower's First Amendment rights. It is clear that those responses, at least in part, were in consideration of future litigation and liability that could arise from the placement of known child molesters in positions of leadership and authority within the Jehovah's Witness organization. Watchtower has provided us with no authority under which such documents would enjoy First Amendment protection. Its argument appears to be that these documents are not discoverable because it is a religious affiliated organization. There is no authority for this proposition. We therefore determine that the First Amendment is not violated by the protection of documents responsive to request number 12. Conclusion. Here, Watchtower has abused the discovery process. Again, Watchtower, the appellate court have said that you, Watchtower, have abused the discovery process. It has zealously advocated its position and lost multiple times, yet it cavalierly refuses to acknowledge the consequences of these losses and the validity of the court's orders requiring it to produce documents in response to request number 12. And in a further act of defiance, Watchtower informed the court that it would not comply with the March 25, 2016 order requiring it to produce documents responsive to request 12. The court, following Lopez, Supra 246 Cal App 4th 566, whatever that means, is an incremental step toward terminating sanctions if Watchtower persists in its unjustified conduct, impose monetary sanctions. On the record before us, we are satisfied that the Superior Court's order was not arbitrary, capricious, or whimsical. To the contrary, the Superior Court has shown great patience and flexibility in dealing with a recalcitrant litigant. I should have looked this word up before saying it. I apologize. Who refuses to follow valid orders and merely reiterates losing arguments. We therefore affirm. So Pedron is awarded his cost of appeal. Whew, Watchtower, you have lost. You are showing the world how dirty you guys are when dealing with the courts. And you will just lie. You will rehash old arguments, but the courts can see right through you. Hopefully the floodgates, it looks like the floodgates is being open, wide open, as far as future litigation against Watchtower. They are no longer protected under the First Amendment. The appellate court have decided that Watchtower needs to provide these documents. It is not protected under the First Amendment. So this is a victory for all of those who have been patiently waiting, you know, to get justice, actually. So I just thought I would share this bit of good news. Again, I will leave the link because, as you can see, there are too many pages to actually go through all the details. But this is hot off the press, you guys. Please spread the word and stay safe out there.